आज हम बात कर रहे हैं भारत के मुख्य न्यायाधीश बी.आर. गवई की, जिनका आज सुप्रीम कोर्ट में अंतिम कार्य दिवस है। उनका कार्यकाल भले ही छोटा था, लेकिन तेज फैसले, मजबूत टिप्पणियां और कुछ विवादों ने उन्हें सुर्खियों में बनाए रखा। आज हम आपको दिखाएंगे उनका सफर, उनके निर्णायक फैसले और वे विवादित क्षण जिन्होंने न्यायपालिका को हिला दिया। मुख्य न्यायाधीश बी.आर. गवई एक ऐसा नाम जिसने अमरावती की साधारण गलियों से निकलकर भारत के सर्वोच्च न्यायासन तक का सफर तय किया। उनका कार्यकाल छोटा लेकिन तेज, निर्णय इतने तीखे कि न्यायालय की दीवारें भी उनकी गूंज याद रखे। खजुराहो विष्णु मूर्ति विवाद, सुनवाई के दौरान की गई वो टिप्पणी, जाओ भगवान विष्णु से ही पूछ लो, सोशल मीडिया में आग की तरह फैली। लोग बोले, क्या एक CJI इस तरह बोल सकता है? लेकिन गवई ने बाद में कहा, मैं सभी धर्मों का सम्मान करता हूं। पर विवाद रुक नहीं पाया। 6 अक्टूबर 2025 सुप्रीम कोर्ट की उस शांति को तोड़ दिया गया जब एक वकील ने मुख्य न्यायाधीश गवई पर जूता फेंक दिया। कारण पिछली धार्मिक टिप्पणी का विरोध। कोर्ट रूम में हलचल, सुरक्षा अलर्ट और देश भर में चर्चा। क्या नागरिकों का गुस्सा इस हद तक जा सकता है? एक बड़े पर्यावरण मामले में न्यायमूर्ति उज्ज्वल भुइया ने मुख्य न्यायाधीश गवई के निर्णय की आलोचना की। भुइया ने कहा, प्रिकॉशनरी प्रिंसिपल की अनदेखी हुई है। सुप्रीम कोर्ट के भीतर इस तरह की तीखी असहमति पहली बार खुलकर सामने आई और इसने न्यायपालिका के अंदरूनी मतभेदों पर रोशनी डाल दी। गवई की अदालत में कई याचिकाएं ये कहते खारिज हुई, ये IPL नहीं, पब्लिसिटी इंस्टेंट। कुछ वकील बोले, ये न्याय तक पहुंच सीमित कर रहा है। कुछ ने कहा, ये बेकार याचिकाओं पर कड़ा प्रहार है। लेकिन चर्चा तेज रही। सामाजिक न्याय पर उनका स्टैंड हमेशा क्लियर रहा, लेकिन कुछ मामलों में बहुत भावनात्मक होकर निर्णय देने के आरोप भी लगे। हालांकि गवई ने हर बार कहा, संविधान की आत्मा में समानता पहले है। आज उनके अंतिम कार्य दिवस पर हम सिर्फ CJI को देख नहीं रहे, बल्कि एक ऐसे अध्याय को याद कर रहे हैं जिसने न्यायपालिका को हिलाया भी और जगाया भी और बदल भी दिया।
मैं भूषण रामकृष्ण गवई,
जो भारत के उच्चतम न्यायालय का मुख्य न्यायमूर्ति नियुक्त हुआ हूँ,
जो भारत के उच्चतम न्यायालय का मुख्य न्यायमूर्ति नियुक्त हुआ हूँ,
सत्यनिष्ठा से प्रतिज्ञा करता हूँ
सत्यनिष्ठा से प्रतिज्ञा करता हूँ
कि मैं विधि द्वारा स्थापित भारत के संविधान के प्रति
मैं विधि द्वारा स्थापित भारत के संविधान के प्रति
सच्ची श्रद्धा और निष्ठा रखूंगा।
सच्ची श्रद्धा और निष्ठा रखूंगा।
मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगा।
मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगा
तथा मैं सम्यक प्रकार से और श्रद्धापूर्वक तथा अपनी पूरी योग्यता, ज्ञान और विवेक से
मैं सम्यक प्रकार से और श्रद्धापूर्वक तथा अपनी पूरी योग्यता, ज्ञान और विवेक से
अपने पद के कर्तव्यों का,
अपने पद के कर्तव्यों का
भय या पक्षपात, अनुराग या देश के बिना पालन करूंगा।
भय या पक्षपात, अनुराग या देश के बिना पालन करूंगा
तथा मैं संविधान और विधियों की मर्यादा बनाए रखूंगा।
मैं संविधान और विधियों की मर्यादा बनाए रखूंगा।
Honorable Justice B.K. Upadhyay, the Chief Justice of Delhi High Court, Honorable Justice Madan Lokur, the President of the Trust and former Judge of the Supreme Court, my esteemed colleague Justice Varade, sitting and former judges of the Delhi High Court, Shri Praful Patel and Shri Anand Sharma, the members of Parliament, Shri Mukul Rohde, the former Attorney General for India, Shri Hariharan, the President of the Delhi High Court Bar Association, Ms. Pratnya Baghel, the Secretary of the Supreme Court Bar Association, the other office bearers of the Delhi High Court Bar Association, the Supreme Court Bar Association, KORA, the senior advocates from Delhi High Court and the Supreme Court present here in large number, the members of the bar, the friends from media, academicians, students, the family members of late Justice Sunanda Bhandare and my father's friend Sri Muralidhar Bhandare, Rahul, and Manali. While coming here, I was reflecting on how there are certain individuals we may never have had the opportunity to meet in person, yet their life and work leave a profound and lasting impact on us. They shape the way we think, inspire the values we hold dear, and influence our sense of purpose in ways that transcend time and distance. For me, late Justice Sunanda Bhandari is one of such remarkable personality. Her life continues to resonate as a symbol of courage, compassion, and commitment to justice. Therefore, it is indeed a matter of great honor and privilege to deliver the 30th Justice Sunanda Bhandari Memorial Lecture. Over the years, this platform has been graced by some of the finest legal minds and thought leaders of our time, judges, jurists, scholars, and social reformers, each contributing invaluable insights on questions that lie at the intersection of law, justice, and social transformation. Standing here today, I am deeply conscious of such a rich legacy. To be able to add my voice in however modest a way to this ongoing conversation is both humbling and deeply meaningful. Let me begin by remembering the extraordinary life and legacy of Justice Sunanda Bhandari. She was a rare and luminous blend of intellect, grace, and courage, qualities that defined not only her judicial career, but her entire life's journey. Born on 1st November 1942, in the year that witnessed the stirring of the Quit India movement, she was in many ways a child of freedom, both in spirit and in conviction. The ideals that animated India's struggle for independence, such as equality, justice, and the belief in human dignity, were deeply interwoven into her worldview and later reflected in her approach to law and life. Justice Bhandari came from a lineage that embodied public service and integrity. Her grandfather, R.H. Gokhale, served as the Chief Justice of the Baroda High Court, establishing a legacy of legal erudition and fairness. Her father, Hari Ramchandra Gokhale, was a freedom fighter who carried forward those ideals into the newly independent nation, first as a judge of the Bombay High Court and later as a Union Minister for Law. From such a family, she inherited not just a familiarity with the law, but a moral sense that justice is not a privilege to be exercised by a few, but a duty owed to every citizen. The legacy shaped her understanding of the law as an instrument of social change rather than mere technical interpretations. Her upbringing amidst freedom fighters, jurists, and reformers imbued her with an intrinsic empathy for the marginalized and a deep awareness of transformative power of the justice. At the young age of 26, Justice Sunanda Bhandari was enrolled with the Maharashtra Bar Council, a remarkable achievement at a time when very few women entered the legal profession. In 1970, she moved to Delhi, embarking on what would become a trailblazing journey in the corridors of the Supreme Court of India and Delhi High Court. It was an era when the presence of women in courtrooms was still a rarity and even more so in advocacy roles. The profession, while steeped in notions of justice and equality, often reflected the very hierarchies it sought to dismantle. Courtrooms carried an unspoken but palpable sense of gendered hierarchy. Opportunities were limited, visibility was harder earned, and every success demanded not just skill and intellect, but resilience and resolve. Justice Bhandari faced these challenges with quiet strength and dignity. She navigated a male-dominated profession with perseverance and grace, building a reputation not through rhetoric, but through a sheer quality of the work. Her sharp legal acumen, coupled with a calm and composed demeanor, earned her the respect of her peers and the confidence of the bench. In doing so, She became not just an advocate of her clients, but a symbol of what women could achieve in spaces that had long been closed to them. Colleagues remember her as a dependable, prepared and compassionate, especially towards those who could not afford strong representation. She appeared in Bai Tahira versus Ali Hussain Fisali Chotia case in 1979, a case about the right of a divorced Muslim woman to receive maintenance from her former husband. It was referred to by Justice Lokur. Justice V.R. Krishna IAS judgment in the matter affirmed that right. Justice Bhandare's arguments in this case spoke to her conviction that no faith can justify the abandonment of justice. Around the same time, she also took up a case that was ahead of its time. The inclusion of women in the armed forces. She did not succeed then, but she had the courage to ask the question when it was least inconvenient. That dream was carried forward in Union of India versus Babita Punia and Lieutenant Colonel Nitisha versus Union of India, where the Supreme Court held that women officers must be granted equal opportunity and command roles in the armed forces. Those judgments, in many ways, complete a circle that began decades ago. What was once an argument from the bar has now become a constitutional commitment. I must also take a moment here to commend not just Justice Bhandare, but also her husband, the late Governor Muralidhar Bhandare, who was Murli Kaka for me, and who shared Justice Bhandare's commitment to social justice. In his memoir, he has narrated about the family's resolve to social justice. He has shared how his father invited Dr. B.R. Ambedkar to his family. Let me quote an excerpt from his memoir, and please bear with me as it is a long narration. I quote, Dr. Ambedkar had wanted to visit the burial site of the great Bhakti poet and Saint Chokha Mela, who is buried at the footsteps of the Vitthal temple at Pandharpur. But he was denied entry because, like Chokha Mela, Dr. Ambedkar was a Mahar. Mindful of this shameful denial of entry, in 1936, my father invited Dr. Ambedkar to visit our family temple of Sri Thakurji Muralidhar. Accompanied by leading figures like Yamar Jayakar, a member of the first Privy Council of India, N.V. Gadagi, a freedom fighter, writer and politician, who later served as a minister in the first Union cabinet after independence, and also as governor of Punjab, Anantahari Gadre, Rambhav Mandlik, Rambhav Tatnis, and about 100 other Dalit followers. Dr. Ambedkar entered the temple. To the best of my knowledge, ours was the first temple in India which was open to Dalits. Someone asked Dr. Ambedkar about why he was so passionate about temple entry of Dalits, to which he replied, the issue is not entry but equality. I was not yet 8 years old, but even today, vividly remember standing by my father's side to receive and welcome Dr. Ambedkar. He was not a very tall man, but I remember looking up and thinking how big he was. What a deep impression that historic visit made on my mind and in my heart. I believe it had an abiding influence on my liberalism. It led to a determination in me to become a responsible citizen, caring equally for all sections of society. Dr. Ambedkar used to come regularly on Saturdays to the office of Vivid Vrit, a Marathi weekly, situated in our neighborhood. The weekly was brought out by Rambhav Tatnis. Many progressive leaders of Maharashtra would sit there and discuss the past, present and future of the country. I worked ceaselessly against the practice of untouchability. This determination to create an equitable society governed the actions of both Muralidhar Bhandare and Justice Sunanda Bhandare. Though I did not have an opportunity to personally meet Justice Sunanda Bhandare, I have had a long-standing association with her family, particularly Sri Muralidhar Bhandare, who was a very close friend of my father, and their son Rahul and daughter Manali. As a matter of fact, we reside in the same building at Mumbai. My father and Sri Bhandari shared a bond through their common public life. Both served as members of the Rajya Sabha. Just Mr. Anand Sharma was telling me that he was also a member of Rajya Sabha during that period. Their shared commitment to public service and constitutional values often brought their paths together in spirit. When my father served as the governor of Kerala, Sri Bhandari held the gubernatorial office in Odisha. I also fondly recall that when I was appointed as a judge of the Supreme Court, Sri Bhandari extended his warm blessings and words of encouragement. His grace, humility, and deep respect for the judiciary have always remained with me as a source of inspiration. I recollect when last year I had delivered a speech on Dr. Ambedkar and his contribution to the Constitution. He came to the auditorium in a wheelchair to attend my lecture. I was really moved by his gesture. As a judge of Delhi High Court, Justice Sunanda Bhandari was known for her independence, fairness, and simplicity. She truly believed that law was a tool for social progress, not a preserve of privilege. Her judgments were marked by compassion. Her courtroom was brisk but kind. Young lawyers called her the mother bench because she listened, she guided, and she corrected with care. Let Governor Muralidhar recall that despite being passionate about her work, Justice Bhandari continued to enjoy her hobbies throughout her career and even after her elevation to the bench. At times, she would rush straight from the court to attend an Ikebana exhibition so that she could improve her own flower arrangement skills. A passionate lover of art, she would often deny herself some things just to save money for a painting she liked. Her collection included works of renowned artists like Bendre, Ara, J. Swaminathan, B. Prabha, B. Vittal, M. F. Hussain, Jatin Das, as well as that of a number of young emerging artists. A connoisseur of Hindustani classical music, she celebrated the most significant occasions in her life: the marriage of her children, her 50th birthday, and the birth of her granddaughter, with performances by eminent artists such as Pandit Bhimsen Joshi, Pandit Jasraj, and Shruti Sadolikar. When illness came, Justice Bhandari did not retreat. In 1992, she was diagnosed with a multiple myeloma. She made her doctors promise that they would add life to her years, not years to her life. Even when the disease made it difficult to move, she asked the High Court to build a ramp so she could enter on a wheelchair. 2 days before she left for her final treatment in England, she presided over a full bench in a complex army matter. Despite her pen, she wrote a 78-page judgment striking down an old army regulation that allowed dismissal of personnel without reason. That judgment, later affirmed by the Supreme Court in Union of India versus ex-Major N.R. Ajwani, became a landmark for liberty and procedural fairness. It was her last act of service to ensure that no one, soldier or civilian, would lose livelihood without cause. She passed away on 10th of November 1994, just after her 52nd birthday. Her passing left a silence, but her ideas, especially on gender equality, continue to echo even today. Let me draw a comparison here. Justice Bhandari's formative years at the bar coincided with the rise of Ruth Bader Ginsburg in the American legal world. Both were women of extraordinary intellect, conviction, and courage, who entered the legal profession at a time when few women dared to dream of such paths. Like Justice Ginsburg, Justice Bhandari combined deep legal insight with a passionate commitment to equality and justice. I say this without exaggeration. Had fate not intervened so cruelly and claimed her life too soon, Justice Bhandari would have gone on to achieve accomplishments as remarkable as those of Justice Ginsburg. Her vision clarity of thought, and empathy for the marginalized had already set her apart as one of the most promising legal minds of her generation. Her legacy is now carried forward by her daughter Manali Singhal, who is a lawyer at the Supreme Court, and her granddaughter Shreya Singhal, who is also a lawyer. Most notably, Justice Bhandari's fighting spirit is evident in the PILs filed by her granddaughter, which have led to landmark judgments such as Shreya Singhal versus Union of India, where the Supreme Court declared Section 66A of the Information Technology Act 2000 unconstitutional for violating the rights of freedom of speech and expression guaranteed under Article 19(1)A. I extend my best wishes to her family. Let me now turn to the theme of my address today, Justice for All, building a gender equal and inclusive India. To meaningfully explore this subject, I have chosen to trace our history in three distinct phases of 25 years each, beginning from 1950, the year our Constitution came into force. Each of these phases represent a crucial stage in India's constitutional evolution. The early years of nation building and rights realization, the period of social and judicial transformation, and the contemporary era where the equality and inclusion are being reimagined in the light of new challenges and aspirations. Through this lens, I hope to reflect on how far we have traveled in realizing the constitutional promise of justice for all and how much further we must go to build a truly gender equal and inclusive India. When the Constitution of India was being drafted, the framers were actually conscious of the deep-rooted social inequalities that had long structured Indian society, whether on the basis of caste, class, or gender. They understood that the idea of justice would remain incomplete unless equality was made both a constitutional ideal and a lived reality. Therefore, the Constitution's framers enshrined powerful guarantees in the Fundamental Rights chapter. Article 14 lays the foundation by proclaiming that every person is equal before the law and entitled to equal protections of the law, a principle that has since guided our democracy's moral compass. Article 51 goes further to expressly prohibit discrimination on several grounds, including sex, thereby acknowledging gender-based disadvantage as a constitutional concern. Importantly, Article 15(3) authorizes the state to make special provisions for women and children. This clause was not merely a gesture of goodwill, it was a deliberate constitutional design to ensure that affirmative and protective measures for women's advancement would have clear legal legitimacy in the years to come. Long before many other democracies extended equal protection and political rights to women, India's constitution adopted universal adult franchise from the very beginning. Every woman in independent India stood equal to every man in the exercise of her most fundamental democratic right, the right to vote. In doing so, our constitution laid down one of the strongest foundations for gender equality and justice, transforming the promise of equality from a moral aspiration into a constitutional guarantee. Among the directive principles of the state policy, Article 39A directs the state to ensure that men and women have equal rights to an adequate means of livelihood. Article 39D requires the government to ensure that men and women are paid equally for equal work. Further, Article 42 requires the state to provide not just on human conditions of work and for maternity leave. Building upon the constitutional guarantee of equality and non-discrimination, the early decades after independence witnessed a transformative wave of legislations aimed at reshaping women's position in both the private and public spheres. Guided by the vision of the constitutional framers, these reforms sought to translate formal equality into substantive empowerment. The most far-reaching among them were the Hindu Code Bill, a monumental legislative project that redefined family relations, inheritance, and property rights for millions of women. Spearheaded by Dr. B.R. Ambedkar, and later carried forward by successive leaders. These laws marked the first systematic attempt to align India's personal laws with the constitutional ideas of justice and equality. The Hindu Marriage Act 1955 introduced revolutionary changes by granting women the right to divorce and remarry, which were rights previously denied under orthodox religious laws. It outlawed polygamy and child marriage, recognizing women as an equal partner in marriage and not merely as dependents within it. The Hindu Succession Act 1956 further advanced gender justice by conferring upon women full ownership rights in property and recognizing daughters and widows as equal heirs. By abolishing the limited estate doctrine, it transformed women's rights from mere life interest to absolute ownership as an emphatic assertion of economic agency. The Hindu Adoption and Maintenance Act 1956 extended the power of adoption to women and secured their right to maintenance, including post-divorce support, affirming women's capacity for independent decision-making and economic security. Complementing this, the Special Marriage Act 1954 offered a secular framework for marriage, facilitating unions across caste and religious boundaries. In doing so, it recognized women's autonomy in choosing their life partners and challenged entrenched social hierarchies that had long constrained their freedom. The Dowry Prohibition Act 1961, by criminalizing the giving of and receiving of dowry, sought to address one of the most pervasive and violent manifestations of patriarchy in Indian society. Though enforcement remained weak, it marked an important acknowledgement by the state that marriage could not be a site of coercion or commodification. Similarly, the Maternity Benefit Act 1961 established women's right to maternity leave and protection from dismissal during pregnancy, recognizing reproductive health as an inseparable component of workplace equality and dignity. Collectively, these enactments represented not only legal reform, but a moral and social reconstitution of Indian society. They sought to dismantle the structural inequalities embedded in family and custom, bringing women from the margins of dependency to the center of constitutional citizenship. While their implementation encountered resistance and uneven progress, these laws laid the groundwork for the ongoing struggle towards gender equality, transforming the promise of the Constitution into a living reality for generations of Indian women. I'll come to the second phase between 75 to 2000. After 1975, the national discourse on gender equality began to evolve beyond questions of formal rights, turning instead towards the deeper idea of dignity as an inseparable component of equality. The conversation shifted from a mere legal parity to the recognition of the woman's autonomy, bodily integrity, and the social realities that shape their lived experiences. A defining moment in this transformation, though one born out of a tragedy and institutional failure, was the Supreme Court judgment in Tukaram versus State of Maharashtra, popularly known as Mathura case. In this case, the Supreme Court acquitted two policemen accused of raping a young tribal girl inside a police station, reasoning that her consent was voluntary because there were no visible marks of physical resistance. The judgment reflected a deeply regressive and patriarchal understanding of consent, effectively denying the social context of power, coercion, and vulnerability in which sexual violence often occurs. In my view, this decision remains one of the most troubling moments in India's constitutional and judicial history, and it could be called as a moment of institutional embarrassment, where the legal system failed to protect the dignity of the very person it was meant to safeguard. Yet this judgment also became a turning point. The public outrage and the nationwide protests that followed, led by women's groups, students, and legal activists, ignited the modern Indian women's rights movement. It compelled the nation to confront the inadequacies of its criminal law and catalyzed the amendments in criminal law, which redefined the concept of consent and strengthened legal protections against custodial rape. Following this, further legislative measures were undertaken to reinforce women's rights within the family and marriage. The Dowry Prohibition Act was amended in 1984 and 1986 to strengthen penalties for dowry offences. Family Courts Act 1984 was enacted to establish a specialized courts for speedy resolution of family disputes. Alongside these statutory developments, the judiciary played a crucial role in giving life to the spirit of equality enshrined in the Constitution. In the celebrated case of Air India versus Nargis Mirza, a group of air hostesses challenged discriminatory service conditions under the Air India Employees Service Regulations, particularly those that made them retire upon marriage if within 4 years of the service or on the first pregnancy or at the age of 35, whichever came earlier. The Supreme Court held that the rule mandating retirement on first pregnancy was unconstitutional and arbitrary, as it treated women unfairly based solely on sex, which was in violation of Article 14 of the Constitution. In Mary Roy versus State of Kerala, the petitioner challenged the Travancore Christian Succession Act, which discriminated against Syrian Christian women by giving them lesser inheritance rights than the men. The Supreme Court held that the Indian Succession Act 1925 applied also to the Syrian Christians of Kerala, thereby granting equal inheritance rights to women, affirming the principle of gender equality under Article 14. During this period, the judiciary also began to draw upon international human rights instruments to enrich and expand the interpretation of women's rights under the Indian Constitution. The courts recognized that the principles embodied in documents such as Universal Declaration of Human Rights, the Convention on the Elimination of All Forms of Discrimination against Women, and the International Covenant on Civil and Political Rights could serve as a persuasive source for advancing gender equality. By evoking these global norms, the courts infused constitutional interpretation with a broader moral and comparative perspective. In the landmark decision such as Vishaka versus State of Rajasthan, the court called sexual harassment of women in the workplace a violation of the equality principle. The Supreme Court explicitly relied on SEDA to formulate binding guidelines against sexual harassment at the workplace, filing a legislative vacuum with principles derived from international law. This approach reflected on an evolving constitutional philosophy that the rights of women are not confined to domestic statutes, but are part of the universal struggle for dignity and equality. In doing so, the judiciary reaffirmed that India's constitutional vision of justice is in harmony with the global human rights movement, and that international law can be a catalyst for progressive transformation within our own legal system. The Vishaka judgment later led to the enactment of the Sexual Harassment of Women at Workplace Prohibition, Prevention and Redressal Act 2013. This legislation gave legal force to the Vishaka guidelines and made it mandatory for all workplaces to have an internal complaints committee. It marked a major step towards making workplaces safer and more equal for men. In Chairman Board, Railway Board versus Chandrima Das, the Supreme Court gave a powerful articulation of gender justice and human dignity under Article 21. The court emphasized that the protection of life and personal liberty extends to every woman, regardless of her nationality, social status, and legal identity. By recognizing that right to live with dignity belongs to all women within India's jurisdiction, the court underscored that gender-based violence is not merely a personal wrong, but a constitutional violation. The state, it declared, carries an affirmative obligation to protect women from such abuse and to provide effective remedies when that duty is breached. In affirming compensation to the survivor, the judgment marked a significant moment in the evolution of gender-sensitive constitutional interpretation, where women's rights were viewed not only through the lens of individual justice, but as a collective reaffirmation of the state's commitment to the gender equality and human dignity. Now let me turn to the last 25 years. In this phase, laws and court judgments began focusing not just on preventing violence or discrimination, but on giving women equal voice and opportunity in every sphere of life. Issues like workplace safety, representation, reproductive rights, and equal pay came to the forefront. We saw the enactment of Protection of Women from Domestic Violence Act 2005, which provided the first civil law remedy for domestic violence in India. The Act defined domestic violence broadly to include physical, sexual, verbal, emotional, and economic abuse. It extended protection beyond married women to include sisters, mothers, and women in live-in relationships. The Act provided multiple relief mechanisms such as protection orders, monetary reliefs, and compensation. Following the brutal gang rape in Delhi in December 2012, the Parliament enacted Criminal Law Amendment Act 2013, which expanded the definition of rape and introduced stricter penalties for sexual offences. It also introduced new offences such as acid attacks, stalking, and voyeurism. It provided for the death penalty in cases causing death or vegetative state of the victim. The Maternity Benefit Act 2017 was also recently introduced. The amendment increased paid maternity leave from 12 weeks to 26 weeks for the first 2 children. The idea of gender equality also grew broader, embracing queer rights and inclusion of transgender persons in judgments such as Nalsa versus Union of India and Navte Johar versus Union of India. Furthermore, the understanding of women's reproductive autonomy was reaffirmed in X versus the Principal Secretary, Health and Family Welfare Department, Government of NCT, where the Supreme Court expanded the scope of Medical Termination of Pregnancy Act. The court observed that the right to reproductive choice is an inseparable part of a personal liberty and bodily autonomy guaranteed under Article 21, and protection under Act was extended to unmarried women as well. The judgments like Babita Punia and Lieutenant Colonel Nitisha, to which I have already mentioned, the court paved the way of gender equality in the armed forces. Over the last 75 years, India has charted an extraordinary journey in advancing the rights of women and shaping the vision of an inclusive society. From the early struggles for recognition and equality to the present era of intersectional and participatory justice, the courts have often stood as the guardians of equality and human dignity. This evolution has not been without its challenges. There have been moments when judicial interpretations failed to capture the lived realities of women or fell short of the transformative spirit of the Constitution. However, the vigilance of civil society, the persistence of women's movements, and the courage of ordinary citizens have together kept the judiciary accountable to the constitutional promise of equality. Therefore, it is important to acknowledge that the progress in gender justice has never been the achievement of courts alone. The collective voice of the citizens has ensured that regressive precedents were questioned, debated, and ultimately corrected through reform, reinterpretation, or legislative intervention. The dialogue between the courts and the people thus remains one of the most vital sources of India's democratic strength, reminding us that the march towards gender equality is not a destination reached, but a commitment constantly renewed. Despite the progress we have made, the journey towards genuine gender equality remains far from complete. The task before us is not merely to celebrate symbolic achievements or token representations, but to ensure that women have a real and equal share in the space of power, decision-making, and opportunity. Equality must not be confined to numbers or appearances. It must be reflected in the structures, attitudes, and institutions that shape our public life. We must continue to dismantle the invisible barriers, social, economic, and cultural, that limit women's freedom and participation. The rights guaranteed by our Constitution must reach every human, not just those in metropolitan cities or privileged contexts, but also those in small towns and villages and marginalized communities who continue to live at the edges of justice. True equality demands that the benefits of law, education, and opportunity extend to them in full measure. At the same time, achieving gender justice is not the responsibility of women alone. It requires an active reimagining of power by men, especially those who occupy positions of authority in our institutions, workplaces, and political systems. Real progress will come only when men recognize that sharing power is not an act of loss, but of liberation of society. The path to a gender equal India, therefore, lies not in confrontation, but in collaboration, where men and women together rebuild the moral and institutional architecture of equality envisioned by our Constitution. Justice Sunanda Bhandare's contributions towards this journey are truly invaluable. She challenged prevailing societal norms and urged the judiciary to develop a deeper understanding of gender justice and equality. Her resolve to build a society where justice is not just a distant ideal, but a goal that can be achieved through empathetic and compassionate lawyering has deeply influenced the trajectory of the Indian judiciary. And I am confident Justice Bhandare's legacy will continue to create ripples as India navigates more challenges of social equality in the legal realm.